Welcome to this explainer. Today, we're going to unpack a pretty fascinating and honestly highly debated area of criminal law from sections 45 to 62 of the Bharatiya Nyaya Sanhita 2023. It's a concept known as inchoate crimes. Now, if you've ever wondered how the legal system deals with criminals before they actually succeed in pulling off their plans, well, you are absolutely in the right place. Let's get into it. So, let's kick things off with a question that sounds like it's straight out of a sci-fi movie about preventive justice. Think about it. Can you actually be punished for a crime that never even happened? I mean, it kind of feels a bit like mind reading, doesn't it? But as we're going to see, the law actually has an incredibly structured, practical way of dealing with the dangerous buildup to an offense. It's all about ensuring public safety without, punishing innocent thoughts.
To wrap our heads around this, we'll hit 5 key areas today. First, what exactly are inchoate crimes? Second, abetment, or instigating the act. Third, conspiracy, the illegal agreement. Fourth, attempt, which is close but incomplete. And finally, number 5, why do we punish incomplete crimes in the first place?
All right, Section 1. What are inchoate crimes? Let's establish exactly what we're dealing with here. The word inchoate literally translates to incomplete, or in the initial stage. So an inchoate crime involves steps taken toward committing an offense, driven by a criminal intention, but without that final completed result. The absolutely crucial point here is that criminal law punishes certain preparatory acts because they reveal a massive threat to society, even if the final crime isn't accomplished. So the liability here really springs from that guilty mind, combined with the dangerous conduct that follows it. Think of a crime as a journey that generally passes through 4 stages: intention, preparation, attempt, and finally commission. Inchoate crimes basically live right there in the middle steps. We obviously don't punish pure intention. Just thinking about something isn't a crime. But inchoate crimes target those limited cases of preparation, the actual attempt itself, and participation in planned offenses. Moving right along to Section 2, abetment. This is all about instigating the act. You know the phrase guilt by association? While people who encourage or assist a crime are held morally and legally responsible, even if they don't directly commit it. Under the BNSS, the law identifies 3 main modes of abetment. First, instigating another person. Second, engaging in a conspiracy to commit the offense. And third, intentionally aiding the commission of the offense, like maybe supplying weapons or giving information to help a getaway. The person doing this is called the abetter, and the law makes absolutely sure they can't just wash their hands of the crime simply because they didn't pull the trigger or steal the goods themselves. To put it into perspective, imagine this scenario. Person A persuades person B to commit theft. If A provokes B through words, conduct, or even a willful misrepresentation, that right there is abetment by instigation. B might be the one actually breaking into the house, but A is the puppet master, the driving force. The law recognizes that indirect criminal participation is incredibly dangerous and absolutely has to be discouraged to keep society safe.
And the courts don't take this lightly. They actively look for participation or encouragement connected to the principal offense. A perfect example is the notable case of Ramesh Kumar versus State of Chhattisgarh. This case deeply discussed the essentials of instigation, specifically in the really severe context of the abetment of suicide. The courts emphasized that there has to be a clear active push, a real provocation that drives the other person to commit the act. It basically proves that mere words can absolutely be treated as a deadly weapon.
Okay, on to Section 3. Conspiracy or the illegal agreement. Let's see how Section 61 tackles organized criminal plans.
Here's the thing, you literally cannot commit a conspiracy alone. It strictly requires an agreement between 2 or more people. The goal has to be to commit an illegal act, or, interestingly, even a legal act but using illegal means. The whole essence of this offense is what the law calls a meeting of minds. There has to be a consensus and a common design. And once that agreement is formed with criminal intent, the conspiracy becomes a continuing offense for as long as the agreement operates. It's punished entirely as an independent offense to crack down on organized crime and protect national security.
But here's the catch. Because conspiracies are super secretive in nature, proving them can be incredibly tough. Criminals don't usually sign written contracts, right? So courts often have to rely heavily on circumstantial evidence and the conduct of the accused to prove this dangerous meeting of minds actually happened. This exact issue was thoroughly examined by the Supreme Court in the case of State NCT of Delhi versus Navjot Sandhu, where they broke down the exact proof and ingredients needed to establish that a criminal conspiracy existed behind closed doors. So just to clearly distinguish the two concepts we've covered so far, think of it like this. Abetment can often be a one-sided push. You can instigate someone who hasn't really agreed yet, or you can secretly aid someone. But conspiracy, that absolutely demands a mutual agreement. There must be a firm consensus between the parties. Understanding this difference is a real game changer for seeing how the BNS layers its approach to catching different types of criminal involvement.
That brings us to Section 4, Attempt. Close, but incomplete. Let's look at Section 62.
This is where things shift. Attempt begins exactly where preparation ends. Preparation is just arranging the means, like, say, buying a crowbar. That's generally not punishable because it's a remote stage. You could always change your mind, right? But an attempt is a direct movement toward the offense. You've crossed the line into an immediate, punishable danger. The harm might have been narrowly avoided, but the dangerous act was already set in motion.
To actually prove an attempt in court, the law uses some very specific tests. First up is the proximity test, which asks, was the act close enough to the intended crime? Second is the unequivocality test, checking if the person's conduct clearly and unmistakably signaled criminal intention. And third, surprisingly, the law even covers impossible attempts. This means even if the crime was practically impossible to complete, the attempt itself might still be punishable because the dangerous intention and action were totally present.
The courts lean really heavily on that proximity test. We saw this perfectly illustrated in the pivotal Supreme Court case, State of Maharashtra versus Mohad Yaqub. The court discussed exactly where to draw that really tricky line between mere preparation and a full-blown, punishable attempt. It's a delicate balancing act between trying to prevent a crime and the strict requirement that there has to be a clear, overt act closely connected to the intended offense.
Finally, Section 5. Let's zoom out a bit. Why punish incomplete crimes in the first place?
By punishing abetment, conspiracy, and attempt as their own independent offenses, the law is basically acting as a shield. It's playing defense. The goals are straightforward: prevent serious offenses, protect public safety, punish dangerous conduct, and deter organized crime. The legal system doesn't want to just sit around and wait until a person is hurt or a building is damaged to step in. It intervenes early to dismantle bad actors and prevent a much greater harm from ever manifesting. And that right there is the core takeaway of our explainer today. The Bhartiya Nyaya Sanhita isn't just about reacting to damage after the fact. It's fundamentally designed as preventive justice. But it carefully balances this early intervention by demanding undeniable proof of clear criminal intention and concrete actions. It makes sure we aren't prosecuting people for thought crimes, while still aggressively stopping coordinated criminal conduct right in its tracks. As we wrap up this explainer on the BNS, I want to leave you with something to ponder. Where exactly do we draw the line between a dangerous thought and a punishable crime? It is an incredibly delicate balance between preserving our personal liberty and ensuring robust public safety. But hey, next time you read about a foiled plot or an arrested conspirator in the news, you'll know the exact legal mechanics at play behind the scenes. Keep exploring, keep questioning, and I'll catch you in the next explainer.